secondary organs. And this one, we may not necessarily have to waste too much time on it because I'd hinted on how it works in our class yesterday. So what's the idea? The idea is that, see, we have been stating that when a person, a third party or an outsider wants to deal with the company, we have noted that the company is largely the members in general meeting, the board of what? Directors, who are the primary organs. We have concluded, we are, all of us now, we now know, including you, Zainab, we now know how liability may be attached to what? To the company. From the actions, from the decisions, and even from the knowledge of the primary organs. But when you look at 87 sub 1 of Comma, it has already hinted that a company shall act through MDM, BOD, or officers or agents appointed by them. So which means that companies do not act only through the primary organs. Companies may also act through the what? The secondary organs. So who are the secondary organs? They are the agents of the company and what? The officers of the company. Are we together? Now, the idea of agents of the company means that anybody that the company has authorized. Now, what does that mean? It means the person may be within the company or the person may be what? Outside what? The company. Do you understand what I'm saying? What it means is that this agent may be a shareholder of the company, may be a director of the company, may be an employee of the company. Are we together? But it is also possible that it is even somebody that is outside the company. Do you get? Remember the scenario we painted yesterday. A company that enlisted the service of a recruitment what? Agent. That is a different company what? Entirely. But they said, go and do this thing for us. That means that's recruitment what? Recruiting what? Agency. That company is acting on behalf of another company. They are agents. Are we together? So agents may be within or outside. Are we together? Officers of company. Come as defined what? Officers. To include what? Directors, company secretary, and any other person that the company describes as what? As an officer of the company. So the idea is that these are the secondary agents. And the idea is that these secondary agents, they can bring about liability to the company. That is, their actions can bring about liability to the what? To the company. Just the same way the actions of the primary organs could bring liability to the company. Now, yesterday, I noted that even though the primary organs are the company, right? They act as the company in given circumstances. And I told you that dealing with the primary organs promotes what we call security of transactions. Because what we mean by security of transactions is that there is that assurance when you are dealing with them that, oh, you know you are dealing with the company. So there won't be an issue of when liability arises. Maybe the company is supposed to pay you or whatever. The company will not start saying that it is not liable, it's not corporate liability, that is personal liability, you know. So, but if you deal with the secondary organ, that issue what is very much what alive. Now, having noted that, one thing I also mentioned yesterday, and which I'm also re-emphasizing, is that practically majority of the transactions that would involve, not just transactions, majority of the dealings that would involve a third party would actually be carried out by the secondary organs. Are we together? Because the thing is this, you cannot expect that every action that needs to be taken, every decision that the company needs to take that would involve a third party, they should always come and pass what? Board resolution. They should always come and call for general meeting for them to come and be passing ordinary special resolution. Or if it's a private company, you can't expect that is going. How do you do business? Do you understand what I'm saying? So you need a low cost what? Decision making framework. Are we together? So that low cost decision making framework means that the primary organs can reserve some what? Decisions towards for themselves. To say, oh, some of these decisions, usually because of the value of the decision, the sensitivity of the decision, the scale of the what? Of that particular transaction, right? They can reserve it and say, oh, this one, so we are the ones that can take actions on them. We are the ones that can take decisions on what? On them. But you cannot say that only the MGM and the BOD should be taking what? Decisions, actions. No, you can't. Are we together? And it's not practicable. So what that now means is that what they can do is the law says he who acts through another acts for himself. Rather than them trying to do everything by themselves, they can what? Enlist what? Instrumentality of another person, another entity. Are we together? That would be able to do that in a faster, swifter what? Manner. Are we together? And when these people do these things, the primary organs are taken to have done it. So if the primary organs are the company, it then means that what? The company has what? Has done it. Are we together? So it means that corporate decision making, corporate actions straddle between decisions taken by the primary organs and those by the what? By the secondary organs. Most of the decisions of the company in their dealing with what? Third parties are typically going to be through the secondary war organs. Is that understood? And that is where the problem arises. Because when you deal with what? The secondary organ, the security of transaction, right, is lower. Because there is a tendency of dealing with a secondary organ that has no authority of the primary organ. Are we together? Secondary organs typically are not the decision makers. It's the primary organs. But because primary organs cannot always take all the decisions, it's not practicable. They need to now give authority to so which then means that you have to show that there is that what? Authority. And that was why the example I gave yesterday about the interviewee, right? The applicant went for the interview only to realize that the HR in the mail made a mistake as to what, as the, and she had incurred what? Expenses and whatnot. Unfortunately, she went for the interview and they sent her what? A mail to say, we regret to inform you that will not be going with. And then it felt like, after you have made me to spend 2 days, I understand what I'm saying, and I've incurred what? Cost and everything, you have to pay me. So you sue the company. So the question will now be, if you say you are suing the company for what? For a mistake, isn't that so? But the question is, who made that mistake? The question will be, you can only sue the company if it is the company that made the mistake, right? So it means that you have to prove that it's a corporate what? Action, that is, that mistake is by the company. So how can the company make mistake? Typically, the company should be making mistake either because it's the MGM or the BOD that made that mistake. But in this situation, it's neither the MGM or the BOD that sent that mail, isn't that so? It's the HR. So the question now is whether the HR's action can be attributed. That's where the doctrine of attribution comes in. Can be what? Attributed to the company. And we said for you to say that the HR's action can be attributed to the to the company, you must be able to prove that the HR had the authority to do what he had done. And that authority must have come from what? From the MGM or BOD. Of course, it doesn't mean MGM or BOD will directly authorize the HR. There will be what? A chain or line of authority. Are we together? And I told you that things like that is usually something to be done by the board of directors. Are we together? Recruitment and whatnot. Something usually to be done by the what? By the board of what? Board of directors. Are we together? So the way board of directors handle things like that is that they will now delegate it. It's the board as a whole. But that within the board, the board governance architecture too now. There's the management, isn't that so? So they will now put it there. So within the board, there is now the management. So as you have the management, so most times the board would have authorized the management to handle things like that. Are we together? So most likely it's going to be the management that would, and we said maybe the MD that has authorized what is it called, the chief what is it called, HR or whatever, to handle that, and that one is the one that gave the HR the instruction. And so there is, so you have to prove that, you have to still tie it back to the primary organs. If not, there will be no liability. That is when you are using agency, right? That's when you are using agency. But agency is not the only way to make a company liable by the actions of the secondary organ. Agency is not the only way. Another way to make the company liable by the action of the what? The secondary organ is what? Vicarious what? Liability. Is what? Vicarious what? Liability. Vicarious liability. Vicarious what? Liability. So, and you know, vicarious liability here, what you are just doing is you are saying that, see, this person is an employee of the company. And this person, in the course of what? Of our employment, has what? Committed what? A tort, a breach. The tort here is the tort of negligence, isn't that so? So based on that, you are still saying the company should be alive. But you see that even for vicarious liability, you must still prove, you must prove that this person is an employee of the company. So that means the company must have employed. So who is now the company for the purpose of employing the HR? The company typically will be the MGM or the BOD. But we know that it's not necessarily the MGM or the BOD that would what? Employ what? Employer. Are we together? So things like that are seen as part of the general power to manage the business of the company, employment and what? Getting what? The appropriate what? Personnel, right? So most likely is seen as the general power of the board of directors. So you would have expected that it's the board as a whole that would do what? Appoint. Do you understand what I'm saying? But most times what would happen is that the board may have delegated that to the management to handle or to see to things like that, or the management and a particular committee, maybe the committee for nomination or whatever, for them to what? To handle what? You know, things like what? Things like that. So at the end of the day, if you have already seen that this is part of the general power of the board to manage the business of the company, and the board has now delegated it to a particular what? Authority, and what? And this what? Particular authority has gone ahead to what? To employ. At the end of the day, whose decision is it to employ the HR? Is the board, isn't that so? And is it the board that has the power to take that decision? Yes. Are we together? So that means the company is actually the one that has appointed. So at the end of the day, you are able to prove. Do you understand what I'm saying? You are able to what? To prove. So what that now typically means is that when it comes to what? To the secondary what? Organs, right? What you will use to hold the company, I don't know what's wrong with this thing. What you will use to hold the company liable is going to be the what we call the general or the secondary rule of attribution, which the court mentioned in Meridian Global versus SEC. Meridian what? Global versus what? SEC. The court mentioned it in Meridian Global versus SEC. So, and it is what we call, what you may call the secondary rule, or either you call it secondary or general rule of attribution. Um, Samantha, you raise your hand.
Yes, I just wanted to ask, this second rule of attribution, is it like the third way, or is it like, how would I put it? Is it the umbrella for agency and vicarious liability, or is like the third way after vicarious liability?
Somebody should answer that because I've said this is something I said even in the first class. So who will answer? I said there are three ways, isn't that so? Three rules that govern corporate liability. He said the first one is the primary rule of attribution. He said the second one is the secondary slash general rule of attribution. And we said the third one is what? Direct liability. For primary rule of attribution, we said that applies when you are dealing with the primary organs, which is what we have looked at. Today, we are starting with what? Secondary rule of what? Or general rule of attribution, which arises where you are dealing with the secondary organs. Isn't that so? Then, we said the secondary rule of attribution, the concepts to use are either you are using what? Agency. Are we together? Or what? Vicarious liability. So to answer your question, agency and vicarious liability are the examples of what? Secondary rule of what? Attribution. So this is not third way. This is the second rule that is used to hold a company liable. But when you want to apply this rule, you are either applying the law of agency or vicarious liability. Is that clear?
Yes, thank you.
All right. So now for For the secondary rule of attribution, so the idea is that the moment you have dealt with any person that is not BOD MGM, the only way to hold the company liable is that you are either saying that the person you dealt with is an agent of the company, or when you are talking about what torts and you are saying that the person is an employee of the company and has committed what the breach in the course of employment. Are we together? So for agency, your knowledge of agency is needed here. You remember I said that for the general rule, one of the reasons we also call it general rule of attribution is that it's what we are using here is not peculiar to company law. Are we together? Law of agency is, you can find it everywhere. Employment law, company law. Do you understand what I'm saying? You can find this. This is a general principle of law, right? Vicarious liability is what? For torts, isn't that so? So we are importing them. We are bringing them into company law. So they are general principles of law that we are now adapting into what? Into company law. Are we together? So if your knowledge of agency and law of agency and vicarious liability is what is also needed here. And the law of agency says that what? That where a person, right, authorizes what? Another person to take what? An action also, or to deal with what? A third party on his behalf. The law says the action of that other person, if that person acts within his what? Authority, is attributed to the appointer, who is known as what? The principal. So that is just what law of agency is. If you authorize what? Somebody to go and do something on your behalf, right? And the person has now acted the way you authorized him or her, whatever it is that comes from it, whether benefit or detriment, you will be the one to what? To suffer it. Are we together? And you also be the one to take benefit of what? Benefit of it. That's just what law of agency is what is about. Isn't that so? So now, how do we now adapt law of agency into company law for the purpose of what? Corporate what? Liability or corporate actions. The idea is that we are just saying that a company can also be liable where the company authorizes somebody to go and do something on its behalf. The company will be the principal in that case, and that person will be the what? The agent. If the agent acts within the boundary of his what? Authority, are we together? Then the company is liable. You know that in law of agency, where the principal will not be liable, or in cases where principal will not be liable, one of it is where the agent either acted without authority, like he don't even have authority at all, or act what? Outside his what? Authority. Isn't that so? Mm-hmm. So that is where the principal will not be what? Liable. But the moment the agent acts within his what? Authority, then the principal will be liable. So what does that now mean? It means that the basis of liability for corporate agency is authority. And now, authority underlines what? Agency, isn't that so? For there to be liability in law of agency, you must show that what? The agent had what? The authority of the principal. So it's still the same thing here, where you are the third party is dealing with not the BOD, not the MGM. Any person that can be agent or officer. That's why I took my time to first give you examples of who can be agents, examples of who officers of the company are. You are dealing with one director. There are some times that BOD with the board of directors will take a decision and they will authorize a particular director to go and implement it, to go and oversee it. Do you understand? So in that situation, that director is acting as what? As an agent, isn't that so? Of the company, because the BOD is a what? Is a company, isn't that so? Maybe it is the members in general meeting that are passing maybe an ordinary resolution and they have authorized a particular, even maybe a shareholder, to go and sit with. In that situation, anybody that deals with the shareholder, while the shareholder is acting within the boundary of its authority as contained in the resolution, you are dealing with what? With the company. Are we together? The company is the principal, the shareholder is the what? Is the agent, and you are the what? The third party. Are we together? In law of agency, what the agent does is to bring about what? Contractual relationship, largely. Are we together? Between the third party and the what? And the principal. Is that understood? So it means that even for what? For company law, before a company can be liable for the actions of the secondary organs, you must prove what? Authority. You must prove that what? The particular person that the third party dealt with had the authority. Authority of who? Either the BOD, are we together? Or what? MGM. But remember I told you that authority need not be linear. Authority does not have to be linear. Because at times you may not be able to prove that that person has the direct what? Authority of what? Of the BOD or the what? MGM. Are we together? But what you just have to do is that what? The person that authorizes this person, even if it's not the BOD or what, or MGM. If we trace where this person received the authority from, we can trace it to the BOD or the what, MGM. Do you understand what I'm saying? They authorize the what? The management. Management is headed by the managing director or the CEO, and the CEO is the one that has now authorized you to go and do that. You cannot now say that it's not the BOD, it's still the BOD. So that's why we normally say that what, for secondary organs, are we together? For secondary organs, the way they act by way of delegation and sub-war delegation. Very important, not just delegation, because delegation will come from the company itself, that is the MGM or the what, the BOD. But they also act on what? Sub-war delegation, because the person that the company has delegated it to, are we together, may not necessarily end up being the one that what, that will carry out what, the action. Do you understand what I'm saying? Look at the HR or a branch manager. A branch manager clearly will not have his authority directly from the what, BOD. Are we together? But you should be able to trace that authority back to what? Back to the BOD. So the authority, yeah, so that means the moment you see any scenario, right, where a third party is involved and you are speaking of liability, and it is not that the third party has dealt with the board, they are not saying whether board passed the resolution or whatnot, so that means the third party has dealt with the secondary organ, right? If it is not an issue of vicarious liability, you are using agency, right? You have to be able to say that, see, the reason the company is going to be held liable is because, or is that the person that has acted, are we together, has what? Authority. I'm giving you what? The trick. The moment you are writing on corporate liability or liability for the actions of the company, and it is from what? Secondary organ, and you're not saying anything about authority, you are wrong. Oh. Because on what basis will the company now be liable? Because you have not dealt with the company directly. You have not dealt with the primary organs. You have dealt with the secondary organ. So, and if you have dealt with the secondary organ, and it is not that you are claiming vicarious liability, are we together? In that situation, you have to be able to show that, oh, this person has the what, or had the authority of the what, of the company. Are we together? So your concern should be what type of authority, or how to prove that what he had what authority. But there must be what? Authority. If there is no authority, then the company will not be held liable. Is that clear to all of those of us online as well?
Yeah.
Are we together? So,
Yes, yeah.
so what are the types of authorities generally that we have? The authorities that you need to what, to consider are, we have actual authority, and we have what? Ostensible authority. Actual authority and ostensible authority. Actual authority and what? Ostensible authority. Actual authority and ostensible authority. So these are the two types of what? Authority. Actual and then what? Ostensible. So you must be able to what? You must be able to prove this. Actual authority. Actual authority is now either express or implied. Express or what? Implied authority. Now, what does this mean? Express authority. They actually give you the authority. Are we together? The branch manager, maybe by virtue of what is a contract of employment, are we together, or any other internal decision making process of the company, you can see that they said do this. Are we together? He has the actual authority. So that's why I said the actual authority is either express, that is, you should be able to say whether, oh, orally they gave him that authority, or something is in writing that they said, okay, you can do this. So it's very easy. The express authority would arise typically from, it could arise from maybe your job description. Are we together? If you look at what the contract of employment or the service contract, and they say these are your duties, your roles and responsibilities, and you have done one of those things, there is what? There is already what? Authority, which is what? An actual authority, in that case. Then when is actual authority implied? There are some times, it's not all the time that you have to spell out everything that somebody can do. Are we together? So if you authorize a branch manager and you say that the branch manager should oversee a particular branch, right? And then one of the things he's supposed to do is that he should also oversee how when they open, that branch, and the administrative works and whatever of what. That's expressly stated. But the question is, what does it mean when he's going to what? They are going to look at the administrative, what is it called? What does it mean? How can the branch manager oversee the administrative? It should involve things like the people that are working under him, telling them, okay, put this thing there, put that there. Is that not administrative? But you know that this thing did not exactly say instructing, giving instructions to, it didn't say that, it just say administrative. So implied authority means that those things that you have to do in order for you to be able to carry out the express authority. Express authority here is what? Administrative, right? But of course, now you cannot, administrative does not make things clear, right? It doesn't make things clear. So what does it mean when you say administrative? What exactly would he have to do? It's just like this. Let's say that we say, oh, Zainab, make sure you pass your exam. We have authorized you to pass your exam. But what are those things that you must do to pass your exam? We did not say them specifically. But by saying that pass your exam, we know that it is implied that you should do this in order for you to be able to pass your exam. So those things are implied. We don't necessarily have to state it. Do you understand what I'm saying? So it's still actual. So your implied authority still comes from your express authority. So it's not all the time that you not say, but did not tell him orally to do this particular thing, or in his contract of service or any other document, he did not say that he must do this particular thing. No. We can say that they said he should do this thing. But in order for him to be able to do this particular one that they have expressly stated, he needs to do this. It is implied that he will have to do this. So indirectly, you have also Are we together? At times, implied authority may arise from the position somebody occupies. Are we together? The position somebody occupies. You know that this is the HR of a company. And the HR is telling you that you should come tomorrow for for interview. Would you want to question whether when they employed her as as HR, they told her that she can fix that? You wouldn't, because her role suggests that she has that kind of authority. Are we together? Even if they have not stated it in a contract, are we together, that she can fix? Do you know what I'm saying? But her role as as HR, you understand, it is implied that these are the things that HRs are known for. Do you understand what I'm saying? Somebody says, I'm the chief security officer of this company. You are the chief security officer. You now said, don't pass deal. This is the place that you pass. So that place is armed for whatever. You want to trust in that because this is a matter of security. And if he's the CSO of the company, you assume that it's part of his job description, and it indeed is. Are we together? So that is what implied authority means. Is that understood, guys?
Yes.
So is either you are proving actual authority or you are proving ostensible authority. So how does ostensible authority, how does it play out? It plays out in a situation where someone does not what I mean is, it plays out in a situation where someone does not have the authority, but the principal, you do not have authority to do something, but the principal gives an impression that you have the authority. That's why we call it ostensible or apparent authority. It looks like it is a look like authority. It's not that you have the authority, but the person that is supposed to give you the authority, are we together, is making it look like you have an authority to a third party, and the third party has now relied on it to his own detriment. Then you will now want to turn around to now say, No, this person does not have authority, but you have made it look like this person had what? Authority. Are we together? Do you understand what I'm saying? You have been employed as maybe a company solicitor. Your role, of course, you handle legal matters. Are we together? Maybe you perhaps also act as the company what? Secretary. Are we together? But let's now assume that in this particular company, even though you are a lawyer, you have also been handling things that involve, let's say, maybe logistics or the delivery of the company's what product. We know you are a lawyer, but over time you have been doing that, and there's never a time that the company has come out to tell what third party to stop dealing with what with you. Is that understood? What it means is that the company is creating the impression that you have the authority to what to do something like that, and in that situation, what will happen? In that situation, what will happen is that at the end of the day, the what is it called? At the end of the day, the company will be held liable, not because you have the authority, but because they made it look like what you have what the authority. Do you understand? So imagine if a lawyer can serve as a company secretary, but let's not assume that in this particular company they have appointed another person as company secretary, and you are just the company lawyer, but you have also been acting in the capacity of what company secretary. Are we together? You have not been appointed though, but they have allowed you to continue to act as company what secretary. If any liability arises from that lawyer acting as company secretary, the company will not be allowed to deny. So the idea of ostensible authority is based on the principle of estoppel. Like you are estopped, right? From now turning around to say that, oh, what you made people to think was the true state of affairs, that it was not the true state of affairs. You now want to come and plead the true state of affairs, that no, this is actually it, but you have made a third party to believe that that was the true state of affairs, and the third party has relied on it. Are we together? To his own what detriment, you will not be what be allowed to turn around. So which then means that it is also possible that a company may be liable, not because the person that has acted has what authority. Like there's nothing to show that he has authority, no documents, nothing. Are we together? But you have represented him, you have held him out. And how have you held him out? Because you have allowed him to be what? To be acting in that capacity. Are we together? And so third party had believed that he had what? The authority. Do you understand? So if any liability will now arise in that situation, you'll be held what? Liable. That's also another. And you can look at the case of Freeman and Lockyer versus Bocos Park. Yeah, on ostensible one, authority. Now, please let me state, for ostensible authority to work, for ostensible authority to work, the person or the organ that created that impression or that representation must be the principal. So this is what we are saying. Before the court is going to give judgment in your favor for ostensible authority, you can't say that, my lord, this person acted on behalf of the company, but they are saying that he does not have authority. But he, the agent, made me think that he has authority. Ostensible authority will not apply. The person that will hold the agent out must be the what? The person with appropriate authority to hold him or out. Do you understand what I'm saying? So let's use the David consult, for example. We all know, as far as David consult is concerned, if there is any person that, if it says this person is who you should go and meet, or gives the impression that this person is going to handle this thing, and you can trust that, it will be David himself. Do you understand what I'm saying? But if, for example, you have been, students since 100 levels, 500 level, we have just now employed somebody that is a tutor that has just been employed, and it's not maybe a senior tutor, right? You are not saying that that senior tutor made you to believe that another person is the one that can take that you can send tutorial money to. Also, no, not Ori Davido. Are we together? Not Kenny, not Angela, not the ones that are part of the executive board, this one that we have just what employed, that is also a tutor that you know, is not the one that gave you the impression that what another tutor is the one that you should send what tutorial money to. If you want to claim ostensible authority, yes, did he give you the impression? Yes. But the person that gave you the impression, is he the principal? Is he really the person that had the authority to give? No. Do you understand what I'm saying? So at the end of the day, when you say that you want to use ostensible authority to bring liability to the what? To the company, it has to be that the representation must have come from the organ or the entity that has the authority to what? To make that person an agent. Are we together? It must not have come from somebody that you would not have thought. Are we together? Could have what? Authorized what? Authorized him. Now, note that for ostensible authority, if you add actual notice, if you add what? Actual what? Notice, that, oh, this person, oh, even though they made it seem or look like he has authority, oh, if you had actual notice that he did not have authority, yet you dealt with him, the company will not be held liable. The company will not be held what? Liable. Is that understood? The company will not be held liable. So yes, they make you look like you are the company secretary, but you're not the company secretary. Yes, but you are aware that this person, but yet you dealt with him. You now want to now say, but you have been allowing him to act. You knew now, because the idea of ostensible authority is rooted in equity, estopel, isn't that so? And which is on the basis of we shouldn't punish you when you are innocent, but when you already have notice, you are not what? Innocent. Do you understand what I'm saying? So that is very important. So either it is agency or vicarious what? Liability. For vicarious liability, you are not you are not showing that you didn't get the last principle. Which part, please?
The one on actual authority. They just explain something now, actual authority, under ostensible authority.
Sorry?
Actual notice, not authority. Okay, thank you. Good experience.
Before I explain it, what is ostensible authority? How does it work?
Is when the principal or the person who has authority to make the agent, to make another person an agent, give like to make another person an agent shows that, oh, gives an impression that that third person has authority to act. So the person doesn't have authority to act.
So, and he has given the impression to a third party, and the third party has dealt with that person because the third party felt or thought that he had authority. That's ostensible authority. We now said that if the third party, despite the impression given by the principal, if the third party was actually aware that the agent did not have authority and yet dealt with the agent, the principal will not be held liable, because you were aware. You are only going to be protected when you were not aware and the principal has made you to think that he had authority. That's what I said.
Thank you.
So for vicarious liability, this one is not on the basis of agency, right? It is in a situation where you are saying that a thought has been committed, and there are several thoughts now. You want to enter a bar. A company owns a bar. You want to enter the bar. The security man there said you cannot enter. He said, why? He said you can't enter. He said you've paid, you have tickets, blah blah blah. But before you know it, well, he beats you up. That's assault and battery, right? In law of tort. Depending if you decide to sue in tort, right? You don't want to sue just the security guy, because how much is his salary? So you want to sue the person with a deeper pocket, which is the company. So you have sued the company. You want to hold the company liable. But was it the company that beat you? Do you understand what I'm saying? Was it the company that beat you? Was it the board of directors that came to what to beat you? Was it the MDM that came to beat you? Or was it even the MD as a corporate organ that came to beat you? No. It's somebody at a low what? A low level cadre, right? That beats you up. So in that situation, you want to argue that what? You are not saying that the company has committed the thoughts. No, that's not what you're saying. You are saying that the person that committed the thoughts, his action can be attributed to the what? To the company. I don't know whether you understand what I'm saying. That person is the wrongdoer. But you are saying that even though he's the wrongdoer, the liability that arises from his wrongdoing can be attached to the company. So you are not saying the company committed the tort. So it's not a direct liability on the company. Are we together? The liability, the wrongdoer, that's the reason you can still sue the was no the security man, because he's actually the wrongdoer. He's the primary what? Wrongdoer. Are we together? But you are saying that the company was the one that put him in a position where it could commit what? The wrong. Are we together? So as a result of that, the company should also bear what? Some level of fault. It's fault based. Is that understood? So in that situation, when you want to what? To now do that, what do? You argue that the company is vicariously liable. So you show that what? This person is an employee of the company. This person committed what? A breach, committed a tort, which is the tort of what? Battery, tort of assault. And this person did it in the course of employment. Where was he? In his workplace, isn't that so? He was in his workplace. When he was in his workplace, he was acting as what? A security officer. Which is part of his what? His duties, isn't that so? But you know that the company did not authorize him to beat you. But there's hardly any company that would authorize their employee to go and commit what? A tort. So if we always have to rely on whether a company has authorized an unlawful act to hold a company vicariously liable, we will hardly be able to hold any company vicariously liable. Because will any company authorize you to go and commit what? A tort? Do you understand what I'm saying? Yes, maybe if the company does, it makes it easier. But in most cases, what you have done, right? The company will not have actually authorized you to what? To do it, right? So that is the reason you see that the current position is to say if the wrong that you have done is sufficiently connected to your main duty. Yes, they didn't authorize you to what? To commit the wrong, but they ask you to ensure that what? Unauthorized persons do not enter into the bar. That is what they authorize you to do. But what you have not done, which is to beat the person because the person was trying to find a way into the bar, is it sufficiently connected to your duty? What is your duty? Don't allow unauthorized persons to enter the bar. Is it not sufficiently connected that so many means you may use, are we together, to make what? A person not to what? To have access. Are we together? In that situation, you feel that beating him up is what? Is a way to do that. Is that understood? And is that understood for those of you online as well?
Yeah.
Aha. So that is also so this is also another way to hold what? The company liable through the secondary organs. Then the third way to hold the company liable is through the principle or the doctrine of direct what? Liability. Through the principle or the doctrine of direct liability. Direct liability. Now, direct liability is somewhat similar to vicarious liability, right? But the difference there is that in vicarious liability, I was emphasizing that the company is not the wrongdoer. The wrongdoer is still the employee or the agent of the company. But you are saying that given the circumstance, the company should also share from the liability. So you are attributing the liability or the wrongdoing of that employee to the company. In direct liability, the employee has done something or somebody has done something. Are we together? And you are now saying that what that person has done should be taken as the action of, you are not attributing it. Are we together? You are saying it should be taken as the action of the what? Of the company. That's what we call direct liability. And I know that you people you have heard things like alter ego, directing will, directing mind. Isn't that so? That principle, all those concepts, they become relevant when you are applying what? Direct liability on the company. So let me explain why the court had to come up with this principle of direct liability. The reason is that there are some times that there is a corporate wrong, and that is particularly where a tort is involved or a crime is involved. Are we together? Direct liability is normally used not in contractual cases, because in contractual cases, most likely the company would have dealt either through the primary organs or the secondary organs. So you could actually use what is it called, vicarious liability or um, agency, right? But in criminal cases, yeah, you know that criminal cases largely you can't hold somebody criminally liable on the basis of vicarious liability. A cannot commit a crime and then what? You are charging B to what? To court, regardless of the relationship between A and B, except you can show that what? B has also committed what? A crime, either as a party, you understand what I'm saying, to the what? To the crime. Husband cannot commit crime and he go and arrest wife. It's illegal, right? So generally, if an employee of a company commits crime, because crimes are largely not vicariously, they're largely not vicarious in nature, isn't that so? The company will be telling you, if this person has committed a crime, hold him what? Liable now. You can't say what he has done is the crime of the what? Of the company. That is the company that committed what? The crime. Are we together? They would want to argue that the company would have committed the crime if maybe the members in general meeting they passed what? A resolution to for a crime to be committed. Or the board collectively commits what the crime. But it's very difficult to think of what? A situation where board or MGM will commit what? A crime. Are we together? So most times the crime there would involve somebody within what? The company. Isn't that so? But because crimes are not vicarious in nature, the company want to say he's the one that committed the crime. You can't hold us liable for a crime that he has committed. So the way to circumvent it is to create a law to say that in some cases, when somebody commits what? A crime, that person will not be the one to be taken as committing the crime. It is a company that will be seen as committing the crime. So that is not an issue of holding the company vicariously liable for a crime. It will not be an issue of holding the company directly liable. In the eyes of the law, it is the company that has committed that crime. Do you understand what I'm saying? So there are some times, for example, now that you see in provisions of law that they may say that when a company just maybe enters into a transaction or blah blah blah, that the company should notify, maybe let's say CAC. So the responsibility to notify CAC is who? On the company. Then there might not be a provision in that same CAC that will not say failure to notify, sorry, there might not be a provision in CAMA that will not say failure for the company to notify amounts to a crime and they will be liable for a fine. You see that a crime is involved. Now, how can a company notify CAC? It's a human being that the company will use, isn't that so? In a situation where the human being has not what? Notified what? CAC. The act says that what? That the company has committed a crime. Are we together? But the company may be saying that, by the end of the day, it is this human person that has failed, is the one that is supposed to do this thing. And he has failed to what? To do it. So, it should be the one to be held liable. But the problem is that the wordings of the act said the company is the one to be held liable. Now, maybe it's just normal associates that was supposed to do that thing and has not done it. If you want to find that associate, the associate will tell you that I've not committed what? Any crime. And we say, yes, sir, because it says the company. But the question is, am I the company? Are we together? Yes, I'm supposed to do this thing. But it says the company is the one that has committed the crime. So am I the company? So go and meet what? The company. Are we together? But the company will want to also say, hey, but it's not the BOD or the MGM that failed to do this thing. This is the person that failed to what? To do it. In fact, they may show you to say that's part of his what? His duties. But you can't hold that person to liable for that crime because he will tell you that it is the company that can what? Be an offender here, and I'm not the company. So it now raises what? The question that in situations like that, are there people within the company that when they fail to do something that would amount to maybe a tort or a crime, are we together? And you cannot hold them or liable because the nature of the provision says it is the company. Are there people that they can be taken to be the directing will or mind of the company? Are there other, like aside MGM and BOD, are there other people that their own actions are also taken as the actions of the world, of not being attributed? They, when they said company should do something, when they fail to do it, it is the company that has failed what to do it. Are we together? If the law provides that what, if a company has knowledge of something that the company should do something, are there people that when that person has the knowledge, it is taken that it is the company that has had what the knowledge? So if it fails to what, to do what the law says to do, who has failed to do it? The company, not what, not him. So the head liability also now came from the angle that, see, we may have to now start thinking of company beyond the BOD and the what? MGM. So who else can we see as the directing what? Mind of the company? Who controls the company? Because aside the BOD and the MGM, there might be some individuals too that control what? And that was now what brought about the elevation of the what? Of the managing director. So that of a what? Of a primary organ. That is why when we go and look at section 89 of CAMA, which we'll look at, you see that when it listed MGM, BOD, it also added what? MD. And that is the reason why it is usually now said that the managing director or CEO of a company is the directing what? Mind of the company. That is what we call direct liability. So, because when a crime is involved, in order for a company to be liable, the common law had come up with a concept known as the doctrine of identification. And what is the doctrine of identification? It says, who can we identify? Are we together? Who is that human being that we can identify that is so powerful? Are we together? That his action can be taken to be the action of the what? Of the company. Are we together? So if that person is the one that commits what? This crime, then it is the company that has committed the crime. Are we together? Or that has committed the thoughts? That is where, and so you can then that is now where all those cases that what you're now giving. It started from Meridian. You can look at the case of Tesco supermarket and Natras. Do you understand what I'm saying? All those cases, that's just what they are now explaining as to the people within the company that you can. I think in Meridian, it was even two members of the company, two directors of the company, not the chairman or not the MD, two of them. They were taken to be the directing will and mind of the company. Why? Because it's fact specific. When you look at the fact of the what of the case, they may not have occupied that position. You know, there are some positions that when you occupy them, they are big roles. But they may not have occupied them, but they are big men in the what? In the company. So the fact showed, are we together? So as a result of that, they said these people, you can hold them or not that you can hold them liable, you can call the company liable because you can treat them as the what? As the company. Are we together? The knowledge that they had. And you know, in that situation, the problem was that there was a law that says when somebody becomes like a substantial shareholder, the company should what? So they became what? Substantial shareholder, and the company did not. And the court said, well, they had that knowledge and they were the company. So in that situation, the company could be held liable. So if you look at what was said also in TJ Graham and boating engineering, you understand what I'm saying? Where Lodenick came up with this whole saying that a company can be likened to a human being, isn't that so? It has its hands, right? And it has what? The brain, right? The hands are the ones that take instructions. They will just go and do what they are supposed to what? To do. They are not really the company. because without any instruction they can't do anything. Then now say the brain is the directing what? Mind, because it tells what? The directions of the company. Are we together? So he now say those people that are the directing minds of the company, they are the company. So when you want to look at, oh, whose action can we take as the action of the company beyond the MDM and the what? And the BOD? Then he said those people that form the what? Directing mind. So the controller of a company, are we together? If you're a controller of a company, you have maybe you are the majority shareholder in the company, which then means that most of the decisions that are probably taken by the company, you influence them. If you do something, are we together, that will bring liability, if they sue the company, you can claim that that person is the directing mind of the what? Of the company. And so whatever it is that he has done, the company has what? Has done it. So the way to understand direct liability is to see it from saying that ordinarily MGM and BOD are seen as what? The primary organs, that is the company. But it is possible that the action of someone within the company is also seen as the action of the what? Of the company. I don't know whether you understand it. So there are three things. Remember the three rules to hold the company liable. We said primary rule of attribution, abi. We say general or secondary what? Rule, isn't that so? And we said direct what? Liability, isn't that so? We said primary rule when you deal with what? The company, isn't that so? When they act, these people act as the company, so you are dealing with the company directly. Secondary rule, you are attributing. You did not deal with the company, but you are attributing the action of some people to the what? To the company, isn't that so? Now, when you want to deal with the company directly, you are supposed to be dealing with the MGM, abi? You are supposed to be dealing with the BOD, right? Now, where does direct liability come in? Direct liability has now extended the people that you can deal with as the company beyond what? MDM and what? BOD. So it has said people like the MD, usually because MDs, right? At times, if you see the, you know that the board delegates what? Powers to the MD. At times, we see they would have even delegated almost all their powers to the MD. So who is now the board? The MD is more like what? The board now. Do you understand what I'm saying? So the board, at times, the chairman, normally the chairman should actually not be seen as what? As directing mind. Though. Because why? You know, the chairman is the chairman of the board, but he's not involved in the management of the company. But don't be surprised that in a company that the general power to manage the business of the company that is supposed to be with what? The board. If they have used the articles to give it to the MGM, don't be surprised that the MGM that is now in charge of managing the business of the company may actually be authorizing what? The chairman, or may confer some more powers on the chairman to do so many things, and the chairman will be that what? Powerful. Are we together? Do you understand what I'm saying? So in that situation too, even the chairman at times may also act as what? As the company. And other cases like that you have seen that it's not even what? A matter of whether you are even chairman or what? MD. Question is in the facts was already clear. So like in Solomon and Solomon, for example, Aaron Solomon was the directing mind. So Solomon Limited could have also been liable. Of course, I'm not saying in the context of what happened, though. I'm saying that if a third party had even been involved, I wanted to hold the company were liable by reason of what? Of the action of what? It could have also come from the angle of direct what? Liability. As in Aaron Solomon alone, not as board, not as MDM. Because look at it now. It was whatever it is that he wanted that what the company would have. The rest are just what? Mere nominees. So he was actually the what? The company, even when acting alone. Is that understood? So you can what? Take his action as the action of the company. You can take his decision as the decision of the company. You can impute whatever knowledge that he has on the what? On the company. Do you understand what I'm saying? So all those cases that Prof now gave you, you know, whether Meridian, whether the one Tesco and whether that's HL what, whether that's Telegram and what, voting engineer, all those cases they are on what? Like so once you just hear alter ego, you are talking about directing mind, who is directing mind of the company and whatnot. It's about the direct what? Liability. I know that there's also one St. Leonard's Carrier, yes, St. Leonard's Carrier versus St. Leonard Carrier Asia something, but it's St. Leonard's. When I get the full case, I know it's something like this. I think yes, where I think the company had maybe like a vessel or ship or so, and they named the vessel Leonard's also. So, but when I get it, I'll send it to the what to the group. It's also a case too, right? That also was all about directing mind, who is directing mind of the what of the company. But people tend to make this mistake when you are speaking of directing mind. Before you know it, they are speaking of directing mind of the company. Next, thing we start seeing agency. Next, thing we start, you now be reading, now see attribution. No, you are not attributing. Are we together? You are not what attributing. That person is not seen as what? As the wrongdoer. It is the company that is seen as the wrongdoer. And most times it's because that person may not be what? Cannot be the wrongdoer. Do you get what I'm saying? Like I gave you an example of a crime. He did it, but the provision of the law says it's the company that can commit the crime. If you hold him liable, he will tell you that he's not the one that can commit the crime because it's not the company. If you say the company should be held liable and you are attributing it, the company say you want to hold them liable vicariously, and that crime is not what? Vicarious in what? In nature. So the only way to hold the company liable is to treat him as what? As the company. Abi? To say whatever it is he has done, the company has done it. So he is the what? He is the company. Do you understand what we are saying? Mhm. So that is what? That is that is it. So this is largely, the common law principle. So what we are now going to look at in our next class is what is now the state of the law on corporate liability as far as karma is concerned. And you will see that we don't have to do so much because almost everything that you have been taught, almost everything that was obtainable under the common law, karma has codified. The only thing is that karma has tweaked some things. For example, the issue relating to constructive notice. How that's using what is it called? Indoor management rule to, create an exception for you see that karma has dealt with all those what? All those issues. But every other thing, like direct liability, primary rule of attribution, even this secondary rule of what? Attribution. You will see that karma is talking about actual authority that is expressed implied. You will see that karma spoke about what? Ostensible authority. So karma will just reinforce it. So what we are just going to look at is just for us to go into karma and note those sections that we can now use as the provision of karma on what we have learned, and then note those places where karma has departed from what? From the common law. Are we together? Is that understood, both of you online? All right. So this.
I have a question, sorry.
All right. Go ahead.
Yeah, for this direct liability, is it like on a case by case basis that the court will determine who is the direct, who can be deemed to be directing with a mind of the company, or is it like a general test that the court
Yes,
will just apply?
it's on a case by case basis.
Okay.
That was why I was saying that typically chairman should not ordinarily be seen as the directing mind, but in a particular case, it might be the case. Do you understand what I'm saying? Uh-huh.
Yes, thank you.
All right. So any other question from anyone? I'll call it a day so that I can have a headache. All right. So I will take it as no question, and then we're going to draw the curtain here.
Recording stopped. Thank you, bye.
Bye bye.
Okay.
Hmm?
Are we like,
How now?
no, like disappear.
Are we what?
I think it's expected to be.
I responded now. I shall be human. I responded. Now did I respond to your DM?
We were responding, we not disappear again.
I've been teaching since morning now. So if I respond, I come back to it. I've been teaching now.
We
So
are
I couldn't have.
responding.
I've been
We are
teaching.
responding on.
I would check. I would check and respond. Hmm.